Good morning. My name is Jose Vázquez Figueroa. I'm pro se on this procedure. The reason we are here today is because in the past I was accused I tried to commit a fraud. They say what they alleged I not give it correct information and papers. All this is based on an injury I had. I'm not an attorney. That's the reason I hired an attorney. This law firm got paralegals. I do everything how they're required to me to provide all the information. I do everything well fully true. Today I'm here because the law firm filed a motion with 200 something documents where they alleged that this herniation is an old injury. Now the funny of this is I'm a lack of legal terms or medical reference, but I know by a fact I never have a legal document say can have this herniation where it requires surgery on that specific area, L5S1. Like we already know, the present evidence paperwork is nothing relative to my claim. I don't know how my attorney or the paralegal or how they address this claim. The point is, I had to file this process to try to clarify this misunderstanding. On that court hearing, I never have the right to have a evidentiary hearing. I know that's the reason I got an attorney. And I'm here to find out and relief like that we can review the papers, because the attorney for the supermarket, they never put a motion say can I give it wrong or false information. The only motion they filed regarding about my answers to their requirements is the information is incomplete. And I think if somebody give it incomplete information, have the right to respond, or to both parties agree that the information is fully completed. At this moment, I present on my initial brief information relative on basis of these arguments. Once and again, I'm a citizen who try to explain with my best knowledge my medical condition. I'm not a doctor. A doctor was present to review all the paperwork. It was presented by the law firm. I'm here to explain why this case had to come back to the lower court, because this case was already set up for a trial. And I believe on that process is when the jury can determine if there's any misunderstanding, any problem, or any error with information. But in the meantime, when we are in the discovery process, I think it's correctly make a final decision in something is still on process. I hope after I can come back and retrieve everything what he said. I'm sorry my English is limited, but I feel confident that whatever he allocated from this honorable court, I can give an answer. Thank you.
All right, I'm going to allow you 5 minutes for rebuttal, but right now if there's anything else that you want to tell us, this would be the time to do it.
Well, it's like I say, after the law firm, the supermarket filed these motions, I don't have a control of no documents. It's when I find out, in the past they tried to file a motion to coerce for some information, motion they dismissed between my attorney and them, and now they're using that paperwork like I give it false information about my medical history. It's a motion with 240 documents over there laid down, and nothing saying relative, specific for my claim of this herniation. And the only way I can prove this is we have a real evidentiary hearing. on a specific his claim about I have a bad history on this herniation. What is not true based on the documents that he present to the court. All the evidence is in there. It's just we need a real evidentiary hearing to dig in one by one. Nothing else.
All right, thank you, sir.
You're welcome.
You'll have another opportunity to speak. I'll save you 5 minutes for rebuttal.
May it please the court. Good morning, I'm Colin Strickland. I'm here from the law office of Matthew Scarborough. I represent the Applee WAAS Investments Corp. We're here before the court today on a motion to dismiss for fraud, which was granted by the lower court. As your honors know, the standard of review is an abuse of discretion standard. The evidence that's in the record before this honorable court shows that the trial court was well within its discretion to issue this motion to dismiss order. It should be upheld on the appeal. I understand Mr. Vasquez is putting two arguments forward before this court. The first is that he was not offered an evidentiary hearing with which he had the opportunity to address the allegations that were raised in our motion to dismiss. The record is very clear on that, Your Honor. July the 31st of 2013, an hour-long evidentiary hearing was held before the trial court. Mr. Vasquez was present with his counsel at the time. Mr. Vasquez was sworn in by the trial court and had the opportunity to provide testimony to rebut all of the allegations which were raised by the appellee in our motion. The order that was issued by the trial court expressly states that this evidentiary hearing was held, that the opportunity to rebut any of the allegations that were raised by my client were given to Mr. Vasquez and his counsel at the time, and the trial judge, that is, according to the standard which was elucidated in the Ramey case out of the second DCA, took that opportunity to assess the credibility of the plaintiff at the time, and all of those findings were incorporated in the order which is in the record before this court. The second issue on appeal is whether or not the trial court was within its discretion to dismiss this case. And the record is rife with examples where Mr. Vasquez was provided the opportunity to fully disclose his past medical history. The very first opportunity was in the interrogatories, the standard Supreme Court issued interrogatories which were sent to Mr. Vasquez's attorney. Mr. Vasquez disclosed 2 motor vehicle accidents, 2004 and 2009, did not disclose the name of any doctors with which he treated, any of the injuries he may have sustained. Mr. Vasquez's deposition was taken. He was specifically asked to disclose any prior accidents or injuries that he had. He failed to disclose numerous slip and fall accidents, and perhaps the issue that's most harrowing is this wrestling match he got in when he was a guard, a security guard at a grocery store, I guess, injuring his lower back all the way back in 2001. Mr. Vasquez was asked specifically on the record in deposition, "Sir, did you ever injure your lower back at any point before 2006 and report that to a doctor?" The answer was no. It was not, "I don't remember," "I don't recall." It was an emphatic no. Mr. Vasquez, even here today, has failed to take responsibility for the fact that he himself is his own record testimony, which constituted the fraud, not the testimony of his attorney, the attorney's paralegal. The central issue in this case is whether or not Mr. Vasquez sustained these injuries to his lower back in the fall at my client's property. The line of cases in the second DCA is very clear, starting with the Morgan case, that if a plaintiff lies about an issue that is the very central issue of the case, that is injuries that go to the injury he's claiming as a result of this accident, that warrants a dismissal for fraud. I would like to point out to the court that in the Morgan case and in the Ramey case from 2008, in both of those cases which the second DCA upheld a dismissal for fraud, the plaintiff in that case actually disclosed the doctor with which they had treated and lied about the nature of the treatment they received. Mr. Vasquez failed to even disclose up to 4 medical facilities where he was receiving treatment on his lumbar spine and lower back years before this accident occurred. So following the stare decisis, which is before this court in the second DCA, the facts of his case are analogous to Morgan and to Ramey and go a step further in the fraud. The evidence has shown that Mr. Vasquez consciously essentially entered into this scheme to defraud the court, hampered the defense of this case, and if it weren't for digging on stuff that he didn't disclose when he was directly asked about it, the defense and the court would have never known. It wasn't until the motion to dismiss for fraud hearing where yet another lower back injury, particularly the most significant lower back injury, which was the cause of his lower back problems dating back to 2001, was even disclosed. Again, following the standard before this court in the second DCA, the trial court was well within its discretion to dismiss this case for fraud. There was no abuse of that discretion, and their order should be upheld.
All right. Thank you, sir.
Thank you.
All right, Mr. Vasquez, I'll give you 5 minutes, sir, to respond to counsel's argument.
Thank you, Your Honor.
Before you do that, Mr., I'm trying to get is your full name Jose Alexander Vasquez Figueroa? Is that your legal name?
Yes.
Okay, so that's your property. Because do you go by Mr. Vasquez or Mr. Figueroa?
My last name is Vasquez.
So your legal last name is Vasquez.
Correct.
So where does Figueroa come in?
Okay, I'm Puerto Rican. In Puerto Rico, we use name, middle name, father last name, case the legal name is Vasquez, and my mother last name is Figueroa.
Okay.
You know, it's
so, but on your driver's license or on whatever, what is your correct
well,
name?
back on 1999 is Jose Alexander Vasquez Figueroa. When I
Okay.
moved to the state of Florida, they changed it to Jose Vasquez, and after the 9/11, the federal level required as it's right in your birth certificate. Now I come back to be Jose Alexander Vasquez Figueroa.
Okay, and the lawsuit below that was filed by your lawyer, what was the name given in the lawsuit below?
Well, my lawyer, for me, I understood, he only filed by Jose M. Vasquez.
Okay, so right now, if we call you, it's Mr. Vasquez or Mr. Figueroa?
No, Mr. Vasquez.
Okay, thank you, sir. Thank you.
Okay.
All right, sir, you have 5 minutes.
Yeah, thank you. Well, Your Honor, like he alleged, back in 2000, he said I have a wrestling match. Where really what happened is I was employed by a security guard company and I got an injury on work. Injury had to be documented as the state required because we're going to prosecute a person. Now, on basis whatever is documented and the final treatment was a knee injury, I don't know how to be nothing with my back problems. What I tried to explain to this court this morning is a lot of misunderstood because they don't see the main issue can have it at this herniation will require a surgery. This kind of medical terms, they got ICD codes for the specific traumas on the body, and I never have been diagnosed or treated for the main situation of this case. Now, I heard the counsel say like they give me time to respond what I wanted to explain to this honorable court. That never happened like that because any communication was through my attorney and they agreed to cancel a court hearings. Document is ready on file. Paperwork I don't find out up to they dismiss this case. On the day that we go to see that motion for dismiss, the judge called the attention to the counsel about it's a misunderstanding and they need to clarify that motion for evidentiary hearing. And the first minutes of that day, the argument about that, and my attorney telling if it's something we can help or discuss. I was here, but really we're going for a motion for dismiss. If we're going to an evidentiary hearing, all the evidence has to be presented before that court date for I can respond. That never happened. No matter what, we agreed to go forward with the procedures. We got 240 pages of paperwork that I never had the chance to touch, to explain to the court. That never happened. What happened is that hearing, what changed, and something I can feel explain, it was a questionary hearing because every time I tried to explain to the judge, Your Honor, that information is incorrect, They tell me, no, sir, respond my question. And that was through question to question, we on review paperwork. And that's why I'm doing my appeal, because it's a lot of misunderstanding on the information he provided. A motion to dismiss, motion the judge grant warning everybody. It had to be changed to evidentiary hearing, but in good faith, to this process move forward, we agreed to sit down and discuss that, because as a person, I had the right to defend myself or retrieve or rebuttal any information, but I never had that right. The transcript is clear about it. I just only responding question. Right now, the history of my back problems is nothing relative to this herniation, which is the main issue of this case. I filed a lawsuit because I got a surgery. It's evidence for years of any kind of injury I got it. And any injury I have a final treatment. I never lied to them or to the court, because all the paperwork is documented. The transcripts can describe every time they jump in from one year to another year. That's the reason I try to explain to them, yes, no, yes, I had this problem this year, but knows what you try to explain to the court. The transcript is clear, but if we don't sit down, relax, and evidentiary hearing, the law firm got to find out where is the misunderstanding. Back in 2006, this law firm represent one of the persons who hurt me in a car accident, and they proved to me that I don't have it, this kind of injury, and I get compensated by this law firm back in 2006, and now they don't remember, they don't bring this paperwork on black and white. What I know is, I never have this kind of injury. I have injury on the past on my knee, I have injury on my cervical, but nothing on my lumbar, on my sacrum. This is the first time.
You need to conclude at this point.
Well, my conclusion,
Yes.
Your Honor, is I appreciate if we can bring this to the lower court, like that we can have a evidentiary hearing on basis of the motion he present, because 240 pages of documents with no medical review or understandings can cause this class of confusion.
All right, thank you, sir.
You're
And
welcome.
you will hear something from us in the mail.
Thank you.
All right. Thank you both. All right, we'll take up the third case, which is Star Insurance versus